Thank you, ladies and gentlemen. This part of the topic is a more intense practical application to the practicing profession. That's not to say that it's unnecessary for a practitioner to be aware of minimum standards and the content. Obviously, that's a starting point when a client seeks advice, but the real practical nuts and bolts of the area arise when the second question is asked, well, having possessed these rights or been subject to these obligations, how are they going to be enforced? What are my remedies? Which court do I go to? Or in which court will I have to defend this claim? And what are the appropriate ways of going about it? And as I said at the outset, Eugene, by reason of his very extensive experience across the whole range of employment law, is uniquely qualified to introduce us to those questions and to provide some answers to them. If he doesn't in the course of the presentation, as I said, there'll be an opportunity at the end of that for members of the audience to ask questions. So I'll hand over again to Eugene to complete his presentation.
Thank you, Don. Now, in relation to this one, I have prepared some notes which were in the folders which were available. So I'll try not to read them. But can I make a couple of observations first? The way the Act is structured, a little differently from previously, is that where obligations are created, there is a separate and direct provision, which isn't new, requiring observance or providing that a party shall not contravene or breach the particular provisions. Those provisions are generally characterised as civil penalty provisions, and thereafter what the Act provides is a list of the types of persons, the type of court and the relevant maximum penalty in respect of each civil remedy provision. So, for example, going back to the National Employment Standards, Section 44 of the Act makes it a provision that an employer must not contravene a provision of the National Employment Standards. Section 539 provides that obligation is a civil remedy provision. So you'll see in paragraph 4 of the notes that I've given that a range of civil penalty provisions are created, and they relate to national employment standards, modern awards. I didn't deal earlier with national minimum wage orders or equal remuneration orders, and are also by Section 323, another matter I didn't deal with in relation to minimum standards, is that there's an obligation on employers to pay, and they've got to pay in money. Goes back to, I remember at university I had to do an essay on the South Australian Truck Act, which prohibited employers not paying in money, particularly remote employees and employers. Sometimes got into a lot of difficulty where wages were paid by way of accommodation, or we'll pay you by a chit to spend at the store which we own. But now you have to get paid in cash. Interestingly, whilst that Truck Act was something in the 1800s or not, a lot of the difficulties with 457 visa holders at the moment relate to this sort of thing. I've heard a number of complaints where 457 visa holders have entered arrangements to repay money, or they live in accommodation provided for the employer. But in any event, a whole range of those obligations are civil remedy provisions. And then once you've established an obligation to comply, or the creation of a civil remedy provision in respect of a breach or contravention, you then go to section 539 of the Act. Section 539 refers to, or sets out in table form, all of the civil remedy provisions, and sets out next to each of those the persons who are able to bring proceedings in respect of them, the courts in which those proceedings can be taken, and the penalty which is applicable. So, for example, if one was to look at, I'll just go a bit of an example. Section 44 provides that an employer must not breach a national employment standard, and proceedings, when one looks at section 539, can be brought by an employee organisation, or an inspector. The courts are the Federal Court, the Federal Circuit Court, or an eligible state or territory court. And there's 60 penalty units, although there's provision made elsewhere for those to be multiplied in cases of breaches by corporations. Now, eligible court includes magistrates' court, so in Victoria, sorry, it should also say it includes a district, county or local court. So in Victoria, breaches can, or proceedings for breach can be made in any of those three courts. There is one exception to which I'll come at a later time. Now, in addition to enforcing the civil remedy provisions, there's specific provision now made in this Act, somewhat analogous to, I won't say that, where if a employer and employee have entered into contractual arrangements relating to the NES, that those contractual arrangements can also be the subject of enforcement. Now, one could always bring an associated claim, that is for breach of award or breach of certified agreement, together with a contractual claim. That wasn't any difficulty. The change, I suppose, is that now there is, where there is a safety net contractual entitlement, that can be enforced as if it was an obligation arising under the Act. All right, now, you'll see in paragraph 8, 7 and 8 in relation to safety net contractual entitlements. So, the first for the hair soup recipe, find your hair, the obligations to comply or not to contravene, I've set out essentially the relevant ones. And then 539 tells you who can bring proceedings, where, and potential remedy. Now, particular penalty. As to remedy, the maximum penalty is by reference to the penalty units which are set out there. Penalty units are as defined in section 4AA of the Crimes Act. Now, one of the interesting things about this Act, which is a bit different from previous Acts, is the broadening out of the remedies which now can be granted by courts. Under section 545 of the Act, the orders that a court can make, they may make any order the court considers appropriate. So that, I think, is an interesting power given to the courts. I can tell you, that unfortunately for both me and my client, the breadth of that power doesn't extend to recreating employment relationships, which have come to an end, although reinstatement is always an option. Now, the breadth of the power given in Section 545 is in respect of the Federal Court, Federal Circuit Court. There are more limited powers in the eligible state or territory courts. Now, as to how the court might exercise that power and how it might exercise any power in determining whether or not a penalty should be imposed, once again, there's no real magic to this, but where courts are called upon to determine the penalty, there is, they all hasten to say, a matter of discretion, unfettered, except exercised judicially. But, however, there are a number of cases which do set out a non-exhaustive list of considerations in determining the penalties which might be imposed. I've given you a list, a reference to a case of Justice Tracy in paragraph 13, but those criteria, once again, there's no magic to any of them. It's the seriousness of the breach, the regularity or the willfulness with which the employer has acted, the level of seniority of the person responsible for the breach, etc. Now, one of the limitations in enforcing national employment standards or other minimum things is that, well, I should say, one of the considerations, it's not necessarily a limitation, is that except where matters are instituted vexatiously or without reasonable cause, it's a no-cost jurisdiction. So if you have a client on either end of a complaint or a proceeding, the fact that it is a no-cost jurisdiction is fairly significant. In terms of acting for an individual, one of the things that the court is able to order, and there's specific provision made for it, is that if there is a penalty imposed on the respondent, the applicant can apply that that penalty be paid to it, or him or her. It's not necessarily the case that any penalty goes off to be swallowed up by general revenue. The courts don't look on that, however, as a substitute for cost, but I think it's probably fair to say that in most circumstances, on an application, the court will seriously consider and quite often grant or make an order that any penalty imposed be paid to an applicant. So there's no cost provision, but that can be good and bad. I suspect that in terms of enforcement procedures for minimum conditions, a lot of people who are on minimum conditions probably have minimum money to pay for any court proceeding anyway. So that brings me to the other way in which cheap, easy and happy enforcement proceedings can be made, and that is utilising the small claim procedure which is provided in the Act. The small claims procedure enables an applicant to bring proceedings, but not for the whole panoply of potential remedy that's available outside the small claim proceeding, but they can bring proceedings in the Magistrates Court or the Federal Circuit Court if there is a claim of $20,000 or less, and if they've properly indicated on the forms that that's how they want the claim to be dealt with. It always seems to be a bit of a cop-out sometimes in some, I shouldn't say that. There's always seems to be some tension, sometimes in tribunals particularly, between the, on the one hand, the desire for tribunals to deal with things quickly, cheaply, reasonably, and not in any formal sense, and then, and on the other hand, applying relatively appropriate standards of proof. In small claims proceedings, the courts are not bound by the rules of evidence and procedure and can act in an informal manner without regard to legal forms and technicalities. To some extent, from what I've seen of some of the cases in the Federal Circuit Court, whilst that assists in part, I think the court still insists on an appropriate level of proof and appropriate evidence. However, where people appear unrepresented, the ability for the court to proceed without being bound by the rules of evidence obviously makes procedures simpler. Now, in terms of advising a corporation, there are limits on representation of corporations. I've given you the name of a case where that's discussed. As practitioners, you should be aware that the limits on representation of individuals has been, in practice at least, if not explicitly, determined by the Federal Circuit Court to the effect that representation by laws will be an exception rather than a norm. Now, one of the interesting things which this Act enables is that if an applicant has a claim against a corporation, it's not necessarily always the case that particularly in minimum wage conditions and minimum wage industries, that they'll be able to recover. But by Section 550 of the Act, proceedings can also be brought against a person involved. What a person involved means is set out in Subsection 2 of Section 550. And if the court finds that a person is involved in a contravention, then they are bound by the same obligations and can be found to have committed a breach as if they were the corporation. Now, some practical matters. I've talked in relation to costs. Each of you have had no doubt different experience in terms of mediation. Each of the courts in which claims can be made have systems of mediation in place. The Federal Court has had a system in place, and its registrars now who conduct the mediations have been doing it for a long time and are very experienced. The State or Victorian Magistrates Court has, I think, case management conferences or whatever. People attend those and you'll have had your own experiences, but generally registrars of the court also conduct mediations. It's not, I don't want to make any comparison, but can I say that my experience, which has been principally in the federal courts, or Federal Circuit Court or the Federal Court, is that the court mediators are extremely good and are able to resolve some very big matters and no doubt very small matters as well. But you have to bring your own experience to how, in the course of running civil litigation in the Magistrates Court, you found the experience there, and bear in mind, if you wish, that other people have found mediators in the Federal Court very effective. I've talked about costs. In terms of the choice of court, once again, you'll bring your own experience to bear. The Victorian Magistrates Court has an industrial division. I think, I might be corrected, that the industrial division sits in Melbourne only. The industrial division has a number of magistrates who have come from an industrial and employment background, either as solicitors or at the bar, and so has, I would think, a fairly high level of expertise. The Federal Circuit Court also has a number of people who have come from an industrial background, but in any event, with the general law work that the Federal Circuit Court does, they come across these types of claims regularly. The federal court obviously has significant experience. So in terms of choosing a court, I don't think you could choose a court on the basis of one particular court having a greater level of expertise than the other. Each court has on the part of the Magistrates Court a specialist division, in the Circuit Court a general law division which deals with a lot of these matters. In large part, I think you'll be informed by your own experience in either of the courts. But bear in mind, if you're a country practitioner or you've got a country client, that I think the industrial division of the Victorian Magistrates Court sits only in Melbourne. Now, in terms of a very practical approach to resolving disputes and forgetting about courts, modern awards are all to have dispute resolution clauses in them. If you find a modern award applicable to your client, then you'd be well advised to look at the dispute resolution clause. The miscellaneous modern award dispute resolution clause includes within it the capacity to notify a dispute to the Commission in relation to matters relating to the NES, for example. And it may well be that an early notification of dispute to the Commission and the intervention of the Commission at an early stage can resolve any dispute without needing to go to court at all. The powers of the Commission are limited. The miscellaneous modern award dispute resolution provision provides that the Commission can exercise such powers as it's got under the Act. At this stage, there's no power of arbitration unless the parties agree, and obviously in a modern award that's not the case. Nonetheless, a mediation or a conciliation or the involvement of the experienced members of the Commission can well nip things in the bud pretty quickly and could save a lot of heartache and expense at a later time. Just more generally, in terms of finding out the sort of basal start of a lot of these things, you shouldn't ignore Fair Work Ombudsman's website. It has a range of information. You should also, I think, in addition to considering litigation, give consideration to whether or not the Fair Work Ombudsman should be involved. They have a fairly large budget for enforcement provisions and their processes, whilst not speedy, are relatively thorough in that if a complaint is made, investigations are made, and generally speaking, if they're satisfied that there is a breach, an opportunity is given to the respondent or the employer to remedy that breach, it can be fairly effective and, once again, fairly cheap option for your client who's seeking to enforce an obligation. So I'm not, as lawyers, talking you out of going to court, but there are at least two other significant non-court options for enforcement. If you do go to court, your clients are able to give consideration to a small claims procedure. Small claims procedure doesn't carry with it the ability to achieve or obtain a pecuniary penalty order. But if you do choose to go to any of the three courts which you're able to go to for a non-small claim procedure matter, then whilst it's a no-cost jurisdiction, at least your client, if it's the applicant, he or she is the applicant, stands a chance of, if successful, obtaining an order that any pecuniary penalty be paid to him or her. It may offset the costs, but it certainly doesn't, it's not a purpose of the pecuniary penalty order, and the courts don't take cost into account in determining the size or otherwise of any pecuniary penalty order. So Don, I think that takes me up to 20 minutes, does it?
thank you again, Eugene, for that very comprehensive presentation. As I said, that really deals with the matters of more immediate practical concern to practitioners. There is a short time available for questions from the floor, so if anybody has one, now's the time to put it. Are there any questions? Yes.
Noting the comments on costs, is there a place for offers of comp, call the bank offers, depending on the type, obviously, if there's a proposed monetary solution? And if so, would they be effective if worded as an amount all in?
Sorry, the limitation on costs, I should say, is also subject to the provisions of Section 570 of the Act. The 570 of the Act provides that a party to proceedings in a court exercising jurisdiction under this Act may be ordered by the court to pay costs only in accordance with Subsection 2, and Subsection 2 says the party may be ordered to pay the cost only if A, court is satisfied the parties instituted the proceedings vexatiously or without reasonable cause, so that doesn't deal with your matter. The court is satisfied that the party's unreasonable act or omission caused the other party to incur the costs, or the court is satisfied of both of the following: the party unreasonably refused to participate in a matter before Fair Work Australia, the matter arose from the same facts as the proceedings. So I suppose I don't actually know of any case where the court has made an order for cost having been satisfied that the party's unreasonable act or omission caused the other party to incur cost. So I think an offer of comp obviously doesn't have the same effect in a no-cost jurisdiction, but arguably an unreasonable failure to accept an offer of comp might be relevant in any application under Section 570.
If I could just add, I think there was, the issue certainly has been raised in what is now the Federal Circuit Court. I'm not sure whether it was ever finally resolved, but certainly the argument was put that I think an open offer had been made, not so much by way of a call-to-bank letter, but at a point in the proceedings, an open offer was made and was refused, and there was an argument that thereafter the party who refused that offer should be ordered to pay the other party's costs. As I said, I'm not sure that the question was ever resolved, but my understanding is that the argument is available, but it might have to be a pretty dramatic sort of case, and the refusal of the offer would really have to be, on my reading of the Act, unreasonable before the discretion would arise. Any other questions? Yes?
My question's slightly off topic, but it falls between a general protections question and yes, entitlements. A lot of workplaces now undertake workplace investigations and sometimes stand aside employees on pay whilst they're conducting those investigations. My query is, what rights does an employee that's been stood down have, given that the employer, it's at their discretion as to how long they're told to stay away from work?
Well, my general starting point, I think, would be that an employer, there is no obligation on an employer, generally speaking, to provide work as long as the employer pays. So my starting point would be, if an employee is stood down on pay while an investigation proceeds, then I think that subject to an inquiry or investigation proceeding, in a relatively expeditious or efficient fashion, then I suspect the employee has very few avenues of complaint about that. That's not to ignore the dispute resolution procedures in any modern award and the involvement in the Commission in the event that that's thought necessary, and who knows what assistance the Commission can give the parties in resolving that dispute.
Are there any other questions? Okay. Well, if there are no other questions, as it seems there are none, I'll, on your behalf, thank Eugene for his very wide-ranging and detailed presentation, particularly for having stepped into the breach created by the unavailability of James Hooper at the last minute, and having so effectively covered the first part of the presentation, which dealt with the content and sources of the national employment standards. So again, on your behalf, I'd thank Eugene for his presentation and ask you to express your appreciation in the usual way.